Welcome to this first World Trademark Review webinar focused on cybersecurity and incident response planning for lawyers and law firms. I'm Tim Lintz, a senior reporter at World Trademark Review, and I'm pleased to be here to cover such an important and timely topic. Before we begin, a few quick notes. For those on the phone for today's webinar, we're muting all attendees to ensure that you can hear our speakers clearly. If you'd like to ask a question to our speakers, you can add it to the questions menu on the webinar software or send an email to webinar@worldtrademarkreview.com. If you'd like to discuss today's webinar, you can use the hashtag WTR Cybersecurity. And finally, we'll be sending out a recording of today's webinar to all attendees within the next week. Anyway, let's get this started. Today's topic was chosen to build upon insights that were presented in issue 64 of World Trademark Review magazine. That edition contained, as always, a selection of highly targeted content for trademark counsel, whether in-house or at law firms. For instance, we turned our attention to the assessment of brand value, outlining the steps that should be taken when dealing with distressed assets. We also provided an international comparison of judicial approaches to internet server provider blocking injunctions, and presented an overview of the factors driving forum shopping in trademark disputes in the EU. I also authored an article that looked to the future of the law firm landscape. While traditional business and pricing structures still dominate, there are many new models shaking up the legal market, some of which could represent the future of the industry. And that brings us to today's webinar topic. No matter what law firm model is being used, the risk of cyber attacks and digital security breaches represent a clear and present danger to law firms, and by extension, their clients. A recent survey from Deloitte, for example, revealed that 58% of business professionals expect IP cyber theft incidents to increase in the next 12 months. And law firms are, of course, a key target. Perhaps the highest profile example, of course, are the revelations from the so-called Panama Papers, which stem from a law firm hack. For firms in the IP space, which have access to sensitive client information, the impact of a breach could be devastating. On the flip side, clients need to have confidence in the plans that partners should have in place and know how they can encourage the adoption of processes which protect their sensitive information. In the current edition of the magazine, today's presenters took an in-depth look into law firm cybersecurity and incident response planning. Today, they'll expand on that topic, identifying what's involved in developing an effective plan to enable the handling of cyber breaches, outlining the necessary components of a breach response plan, and expanding on why corporate counsel should include the development of plans as an integral part of the outside counsel guidelines. First, though, a quick introduction. Steven M Puiszis is a partner and deputy general counsel of Hinshaw Culbertson. He also serves as the firm's privacy and security officer. Steve is a vice chair of the DRI's Center for Law and Public Policy and is a past president of the Illinois Association of Defense Trial Counsel. Anthony E. Davis is a leader of Lawyers for the Profession practice group at Hinshaw Culbertson and advises lawyers and law firms on legal ethics issues as well as on law firm risk management. A lecturer at Columbia University School of Law, he's the author of Risk Management, Survival Tools for Law Firms, published by the American Bar Association. As a quick reminder, if you've got any questions, we'll have a Q&A section following the presentation. So please add your questions to the questions section of the webinar software or send an email to webinar@worldtrademarkreview.com. Anyway, I'll now hand over to Stephen and Anthony to share their experience on this important topic.
Hello. When it comes to data and cybersecurity and the risk of data breach, we believe that a two-tier approach is critical. Obviously, you want to have the best processes and procedures in place to try and prevent a breach from happening. But if a security incident or breach happens, you need to be prepared to address it. We know that technology is not foolproof. Even the strongest technological safeguards or certification with under ISO, under their 27001 standard, is no guarantee that a breach isn't going to occur. And so preparing and being prepared for the inevitable is, we think, critical in this area of law firm and lawyer risk management. The question is no longer if you will be breached, but when and what type. You know, a client may be willing to forgive a lawyer who had a laptop stolen from his or her car, or who may have clicked on a link and launched malware onto their system, but they won't forgive a lawyer who has the chance to prevent that type of security incident from turning into a full-fledged brief. So we think preparation is critical in this area. We have a couple of slides, the first of which is, addressing one of the major ways that law firms are getting hacked these days, phishing emails where lawyers who click on malicious attachments or links. This is happening every day in every law firm globally around the world, and it's a risk that just can't be ignored. 2016 has been dubbed the year of ransomware, and what ransomware is a form of malware that will encrypt anything it can touch, from your computer to shared drives down the road, if it gets past your endpoint security. Statistics show that 23% of all employees click on links that they shouldn't, even after you've tried to advise them. So again, this is another reason why you need to be prepared to address the inevitable when it occurs. The Panama Papers hack was already mentioned, and this has really brought to the forefront globally concerns by clients over their law firm's security. Hackers, it's well known that hackers are targeting lawyers because of the perception that our security is much less than our clients. So it's a time that we really need to be ramping up what we're doing on a going forward basis.
Steven,
now,
can I just dive in about the Panama Papers for a second?
Sure.
I just want to add, I think there are two lessons for law firms about the Panama Papers hack, which was, of course, a firm in Panama. And the lessons are, if lawyers in your firm, and I'm assuming most of the attendees of this are in the intellectual property field, do this. If your law firm and your lawyers regularly associate with lawyers in other countries, it is very critical to your client's data protection that you know what level of data security the firms that you're dealing with have for your client's data. And so much more rigorously in the past, I think it's very important for firms to actually inquire of their offshore colleagues with whom they deal, what level of data security they have, whether they have data protection insurance, which I'm going to talk about a bit later, and just to be sure that you're not dealing with people where, even if the data was secure in your shop, it's totally insecure and it's vulnerable somewhere else because the client won't differentiate. Thanks, Steven.
No problem. I mean, I hate to use this term, but what Anthony just mentioned is an aspect of vendor risk management. Anyone who we place client information with, law firms and lawyers are responsible. So just as one of the initiatives we're seeing amongst law firms in the U.S. is vetting the data security of third-party vendors that assist law firms in providing legal services, that applies equally, as Anthony mentioned, to law firms that you work with and associate with and provide client information 2. So let's talk about some of the basics. Studies generally conclude that more data breaches are the result of human error than hacking. We can talk about lost or stolen mobile devices, improper disposal of equipment, misdirected emails, the risk of malicious insiders, phishing emails, or visiting bad websites, or clicking on links or advertisements that launch malware onto a computer. The individuals in your law firm are probably the biggest risk that client data faces. And so we're going to talk about training shortly, and it is a critical aspect of law firm risk management when it comes to data and cybersecurity. And just as a follow-up on that particular point, there is a perception, especially among younger lawyers, that they don't need training on data security. However, it's been our experience that all lawyers need to be trained on data security because for 2 reasons. One, there are studies out there. One was done by the Harvard Business Review that said your most tech-savvy lawyers in law firms, your millennials, the kids who grew up with technology, are the ones that are most likely to do a workaround your data security policies. And there have been any number of surveys which have revealed a shocking percentage of lawyers don't know that if their firm has data or technology security policies to follow. So one of the things that general counsel of law firms, what we advise them to do is make sure as part of your training that your lawyers know your technology security policies and understand the ramifications if they try to intentionally or negligently try to work around one of those policies. The whole concept of data and cybersecurity involves what I call the unholy alliance of law and technology. It involves lawyers who may not know technology and technologists who don't know the law. So in order to try and bridge that gap, it's critical for law firms to have a strong working relationship between your law firm's general counsel, ethics counsel, risk counsel, whatever label you put on that person, and your IT department, be it a chief information officer, a chief security officer, the head of IT, because the only way you're really going to be able to protect client data is if you merge those two together and you work collaboratively on an ongoing basis. Your general counsel may need to be the advocate for your IT department when it comes to additional outlays of money for technological safeguards. So we're going to talk for a few moments about incident response plans, but before we do that, we want to talk about what are the goals of an incident response plan or an incident response process. It's critical that you be in a position to promptly evaluate any potential security incident or data breach. You need to have the right people involved at the very beginning to determine what the nature of the incident is and the type of response that is needed. You want to be able to make a coordinated response to any security incident or potential breach. You want to be able to contain it quickly if you can. You want to be able to eradicate, any malware or anything that gets into your network. The next step is you want to be sure you can restore the integrity of your network. You want to be able to then evaluate how this happened and remediate vulnerabilities. And in the process of all this, you need to evaluate whether or not you have to notify some regulatory authority or the client about this potential security incident. And the ultimate goal is to protect the firm's reputation and its assets and its clients' information from falling into the hands of of a third party. Your plan has to be flexible. It has to be able to address anything from a lost laptop computer up to a denial of service attack like we've seen recently through the Internet of Things that have recently garnered a lot of publicity. So that's the whole goal of what we're trying to accomplish here, and we're going to talk about how we get there. Now, the worst time to try and figure out what to do and how to handle a data breach is in the throes of when you're in one. If you're not prepared before a breach happens, trying to figure out what to do under the stress of a breach is a prescription for disaster. You're going to be making mistakes. You want to be as prepared as possible. So that's why we believe you need to have a process in place which you then test and work on and evaluate before a breach occurs. Because I can tell you when a breach is suspected, time is of the essence. Security experts will tell you the first 24 hours is critical. So it's what you do once you're first alerted to the potential for a breach that can make the difference between information being exfiltrated out of your firm or not. Now, there's going to be some basic risk management steps that we think you ought to take as you're preparing your incident response. And the first is evaluate where the information is located and how it's accessed. If you don't know where client information is, how in the world are you going to be able to protect it? And how can you take steps to limit the risk in an expedited fashion? Now, this may sound relatively simple and an easy step, but with so much with technology, it's far more complicated than what it appears. You need to be thinking about, do you have information stored in the cloud? Is it in a data center in your country or in a foreign land? Is it on your lawyer's home computers? Is it on flash drives or thumb drives? Is it on a portable laptop computer? Is it on a server within your office or in some foreign state? So you need to figure out where the information is and how lawyers or third parties can access it. Another critical aspect of this whole risk management analysis is identifying what type of information that you have in-house or under your control. And we talk about identifying sensitive or confidential information. Obviously, if you're involved with doing IP or trademark work, that is critical, and you need to be able to protect it carefully. But other forms of highly sensitive information might include protected health information, personally identifiable information, or non-public financial information. And for those of you that are in the EU, you need to understand that the concept of what is personal data or personal information is far broader than what Anthony and I would typically think of in the U.S. It's a far broader concept under your existing directives and under the General Data Protection Regulation that's going to go into effect, I think, mid-2018 now. So once you've identified your information, where it's located, identified sensitive or confidential information, then you want to evaluate who has access to it and do they need the access. And when I'm talking about that, it's not just your lawyers and staff, but third parties. In the U.S., for example, when it comes to protected health information, one of our federal regulations called HIPAA requires that we limit who has access to your information. So one of the things you need to be doing is part of your risk evaluation process as you're setting up your response plan is identifying who has access to the information and how you can limit access to only those who need it. And if third parties have access to your network and potentially to your client's information, you need to be thinking about that as well. You need to identify that and then evaluate, do they need to have access to it? One of the breaches
Steve,
that
can I jump in there for 1 second?
Sure.
I think it's important to note that that's not just about who outside your firm has access to your data and what suppliers you have. There are at least 2 major cases in the United States in the last couple of years of what in the US is insider trading, dealing with securities information that's secret and that affects the market, which is a crime. And in 2 of the incidents, the people who were culpable were employees of the law firm who were not lawyers. They were administrators or assistants who had much too broad an access to the data in the system that they didn't need. So this is both an internal and an external study that you have to check as part of this review.
Right. I mean, obviously, you can do this through group active directories, limit who can access various types of information. Within your document management system, you can limit who has access to various types of information. Those are things that you need to be considering as part of the risk management process. But the reason why we selected this slide with target is to also remind you not to miss the lesson that to be learned from the target breach. And that's about, if you have third parties who can electronically access your network, you need to segment your network and limit to what they can access to and prevent them from actually accessing client information unless it's absolutely needed. You know, the whole thing with target is a hacker got into a third party and was able to then get into the target network through that third party, and they were able to move laterally through the network unencumbered. So one of
Steve,
the things
you need to explain Target for those outside the U.S. That Target is a major retailer in the U.S.
Target is a major retailer in the U.S. You know, $1 billion retailer that has stores around the country and not just limited to the U.S. And what happened is, you know, they allowed a third-party contractor to access their network in order to take certain steps within their stores. The target network did not have any type of segmentation, so that once you were in, you could access virtually anything within Target, and they were able to get to the point of sales at the registers, and they were able to steal credit card information that way, and they were in the network for quite some time. And so that's why one of the lessons to learn from Target is to identify what third parties may have access to your network and limit what they can access to or gain access to. Now, once you've identified your information and where it can be accessed, you need to figure out where are the vulnerabilities, or what are the vulnerabilities at each point. And so, for example, you know, laptop computers, servers, flash drives, all of these things provide access to information. And then the next step is, once you've identified each access point to client information, you want to determine what type of safeguards are in place. And safeguards can be of 3 types. Obviously, you need to think about physical safeguards in limiting who can access your offices, your servers, and things like that. But it goes deeper than that, you know, in terms of clean desk policies. We all have people who gain access for various reasons into our law firms, and if we just leave client information out where anyone can see it, that's one way it can be compromised. You want to have visitor badges so you control who is walking into your in your firms. You want to consider locked cabinets and storage areas. So there's physical safeguards. You want to consider administrative safeguards, which are your policies and practices when it comes to the technology. And then you want to also look at technological controls in terms of, access control. How do we allow our lawyers or staff to gain access to our network? How often do we patch vulnerabilities? Are we using encryption to the broadest extent possible? Do we require two-factor authentication for remote access? When was the last time we've looked at our firewall rules? And have we hardened the perimeter of our firewalls? Do we have intrusion protection or intrusion prevention software? How frequently is our antivirus or anti-malware protection updated? There's a whole host of technological safeguards that you need to be reviewing and considering frequently on a going forward basis. Now, once you've identified the access points and the vulnerabilities, you want to try to remediate them to the best you can through additional or heightened safeguards of the type we've just described. And you want to evaluate your cyber coverage, and I'm going to let Anthony talk about your cyber coverage for these types of incidents.
What I think is very important for everybody to understand is that even if you have a robust and big limit malpractice, lawyer's professional liability insurance policy, it is not going to cover you for many of the costs and expenses that accrue from a breach. What it will do is protect you from client harm if there was some negligence in the failure to either protect the information or manage the breach. But you need to understand very clearly that that policy will not cover you for some of the greatest expenses that accrue inevitably when there's a breach. And first and foremost are what are called the first-party losses, your internal losses, the cost of hiring forensic people to figure out what happened, the cost of making repairs to the system, the loss of the system use, the business overhead expenses that follow, injury to people who are not clients because of your data or because of the breach, reputational injury, loss of business revenue. If you're closed down for days on end, you're going to have a huge loss as you go out, business interruption, in other words. In addition, in many places, certainly in the US, there are regulatory requirements for notification of government agencies. There may be ethical or legal obligations to tell clients. None of those expenses, which can run into millions and millions of dollars, are covered by your malpractice policy. So it is really important, given, as Steven said at the beginning, this is not about if a breach occurs, it's about when a breach occurs, that you have adequate cyber insurance in addition to and separate from your malpractice policy. At present, this coverage is relatively inexpensive to the size of the risk. The other important thing about this coverage, even in relation to loss by clients, is that the attachment point is much lower. In other words, most malpractice policies have a self-insured retention, a deductible that may be quite substantial, and so you're liable for the client's losses up to that amount on your own. Cyber policies attach at $0 or much closer to $0. Stephen, that's what I wanted to say. By all means, add anything.
Right. I mean, the other thing, your professional liability policy won't pay for fines. So frequently, under state laws in the U.S., you can be fined for not providing the appropriate or timely notification. And I understand from that the General Data Protection Regulation that was agreed upon earlier this year, the fines that can be imposed for a data breach are astronomical. I mean, I've seen, you know, it could be percentages of revenue. The fine can be up to 10 million pounds, for instance, and your professional liability policy likely is not going to be covering it, and that's why I believe you really need to be considering cyber insurance on a going forward basis. Now, the other point that we think is critical from a risk management perspective is training your employees on data and cybersecurity. I know a lot of law firms have mandatory security awareness training, and it's not just, you shouldn't be training just your lawyers but your staff as well, because frequently the staff can grant access to the lawyer's computer, or they can be the one that has the malware launched on the computer, which can be the launching pad for the attack in the network. So mandatory security awareness training is critical, but if that's all you're doing, I think you're missing the boat. What we try to do at our firm is every couple of weeks send out an email to all lawyers and staff about a particular security incident. And here's an example of one, for instance, that we have sent out in the past. And really what we're trying to do, and I think this is critical for any lawyer or law firm, is develop a culture of security where everything you do and all the steps you take, you're concerned about the security of your information and the client's information. And so when I send these emails out, typically at the end, what I try to do is I say, if you can learn this, you're in a better position to protect yourself, protect your family, and in the process you'll be able to protect the firm. So I always try to personalize the message, because by personalizing the message and letting the lawyers and staff know that this is for their benefit and not just the firm's benefit, they're more likely to pay attention and do what they need to do. Now let's talk about an incident response plan and team. We believe that having a plan, a written plan, if it's a small firm, you may not need a written plan, but you know, when you're talking about mid-sized firms and large firms, we definitely think it should be reduced to writing. You're going to want to establish an incident response team, and this slide is intended to try and talk about and provide you some concepts of what the team should include. Now, it can vary depending on the nature of the breach. For example, if your employee HR information is implicated, you're going to want to have someone from your HR department involved. You're going to want to have, especially in the U.S. with the growing recognition of infirm privilege, you're going to want to have your general counsel of your firm involved, because if you need to hire vendors or be in contact with third parties, you're going to want to try and protect that under attorney-client privilege. So I think it's critical that you have your general counsel or someone like that as part of your plan. You really need to have someone from your law firm management involved as well, because there may come a time during an incident where you need to shut down your network. And who's going to make that call? I don't think your director of IT is going to want to make that call. So I think it's critical that you have someone from law firm management as part of your team. You need to have someone who knows your information system and your network. So that means someone from your IT department, if you have one internally, or an external IT vendor. You're going to need someone who has the capability to do forensic evaluations of your network. You're going to need people that, at least in the U.S., if a breach occurs, frequently we're required to notify third parties and to offer insurance against identity theft. And so you're going to need to be able to set up 800 call centers, free credit monitoring, and manage the notifications. And there are a lot of third-party vendors that are out there that can do that. And I know most general counsel of law firms don't want to take that on. And that's frequently covered under a cyber policy as well. So you need to identify these, and I think as part of your plan, you want to have your contacts, be it forensic vendors or third-party vendors, on call and available. I know some firms go so far as to actually negotiate a contract with them for services before any breach happens. So all they need to do is pick up the phone, call them, and get them involved, because the last thing you want to do in the throes of a breach is be negotiating the terms of a contract with a forensic vendor. It's going to be critical that for every team member you have at least one backup, because you need to have someone available 24/7, 365 days a year. And then it's going to be also critical to define the roles and responsibilities of each team member so everyone knows who's responsible for taking what steps during the course of a breach. Now, another critical aspect of a breach response is what I call cyber alarms and recognizing your cyber alarms. How are you going to learn that you may have a hacker in your system, or you've got malware that's been launched onto a computer or onto a server? Well, you've got antivirus, anti-malware protection that will provide electronic notices. You may have intrusion detection or intrusion prevention software as well. Hopefully you've got someone monitoring your logs or having a third party monitor the logs of your network. And your employees may recognize something out of the ordinary or unusual as it pertains to your computer. So these are your cyber alarms. You want to know and you want to identify who receives these alarms, how they receive them. And again, you want to make sure you have more than one person who receives these things, because if someone's on vacation for 2 weeks, you don't want a cyber alarm there that could be immediately responded to if they happen to be there. So one of the things we did internally is we set up an email box, breach@hinshawlaw.com, and I'd recommend you consider that as well, because that will allow any employee who sees anything out of the ordinary as it pertains to their computer, or if they get some type of phishing email or suspected phishing email, they can submit it, and it can be promptly evaluated, and you can go from there. I also know that some firms have set up 800 numbers for employees to call. You want to be able to train your employees about these steps to take and what to be looking for in order to have your response plan appropriately staffed and the alarms recognized and notified. So you want to be able to train your lawyers and staff in terms of what are potential signs that a computer may be compromised. And this slide, for example, outlines a number of them. And if your staff and your lawyers don't know to recognize this, then you're missing an opportunity to nip a security incident in the bud and prevent it from turning into a full-fledged breach where information is removed. So again, part of this whole process in terms of preparing and responding for data breaches are training your lawyers and staff to be on the lookout and know what to look for, and then being prepared to immediately report anything that's out of the ordinary. This slide is again important. One of the things that's critical that in terms of preparing a response process is actually performing tabletop exercises where you have a simulated breach happen, and then your employees or those who are part of your response process will actually practice and work through the steps of what they would do if a particular type of breach occurs. And the benefit of doing this is it will frequently identify gaps in your response plan, and it will identify ways to improve it. And it will also eliminate questions that you know, someone on the team may have who may think, well, I thought Joe was doing that, not me. So performing the tabletop exercises once you have a response process and plan in place is important. Now this slide is intended to try and outline a workflow of what the response process should look like. One of the things that we think is critical for a response process is not only a continuous evaluation of the threat, because your initial review of a threat may lead you to believe it's not that significant or serious, but once you get into the process, you may realize it's far more insidious than what you first thought when your team looked at it. So you need to be, your team has to understand that they need to continuously evaluate the threat to the firm and to the client information. Now, the first step obviously is evaluating the notice, the cyber alarm as we called it. Initially, you're going to want to determine, is this a false alarm? Is it really a phishing email, or is it just something out of the ordinary? Is this truly ransomware or what? You want to evaluate if it's a false alarm or a true security incident, and then identify the nature of the incident. And that could, for example, if you've got malware in your system, there are literally libraries identifying forms of malware that will tell you what they're capable of doing or not doing, and you can evaluate your response process or what you need to be thinking about in the initial stages of your response process by evaluating the threat at the beginning. If the initial evaluation suggests you've got equipment that's infected, you want to make sure it's taken offline. You want to prevent it from further infecting your network. Now, keep in mind that if we're talking about a laptop computer that's Wi-Fi enabled, you not only want to disconnect the computer from the network, you also want to disable the Wi-Fi connection so it can't communicate with your network or back to the hacker. If the equipment is on, you want to leave it on. If it's off, you want to leave it off. You don't want to power it on or power it off, because that can impact forensically your logs. And one of the things we're going to talk about is that every switch, every router, every port in your network generates logs of information, and those are critical to your response process. And it's critical if you ever have to be in a position to prove that client information was not taken from the law firm, your logs are going to be critical to that endeavor. Another aspect that people typically may not think about, but in developing your response plan you need to, if your network is down, you have to have an alternative way to communicate with all the response team members. And the other point is, if there's a hacker in your network, are you going to want to be using your network to communicate with one another? The hacker, if they're a sophisticated hacker, if it's a nation state or industrial state-sponsored hacker, they're going to be highly sophisticated, and they're going to be on the lookout for steps that you're going to take to try and limit what they do. So you have to think about alternative ways to communicate between your team members, and that could be involving using home phones or cell phones, personal emails, perhaps text messages. But again, you need alternative ways of your team to be communicating with one another once your system is compromised. I mentioned to you this already. All of these, your ports in your firewall, your routers, your servers, your network log information. And typically the logs can identify when a hack occurred, how the hack occurred, if information was removed or not. So these logs have to be preserved in a forensic way on a going forward basis if you suspect that you've got a cyber incident. So once you've evaluated the nature of the hack or the nature of the cyber breach, it's going to be important that you get people in forensically to evaluate your system and begin to identify how we can eradicate the malware on the network, because obviously that's going to be key. You're going to want to contain it, and once it's contained, you're going to want to eradicate it. Another aspect of your breach response, you have to anticipate that at some point, especially if client information is compromised, there's going to be some publicity about it. Anthony he talks a lot about this, but you want to identify a spokesperson for the firm, and that can be someone internally at the firm or someone externally. You want to have your message at least partially prepared in terms of what you're going to say if you're contacted by the press. Now, I am a big believer in trying to address the issue once and only once. You don't want to keep it in the news. So generally speaking, when we talk to law firms, we suggest that they should, before they speak to the press, they need to be able to address how and why a breach occurred, whether or not client information was compromised and what information was compromised, the steps you've taken to mitigate the risk of harm to the client, and what steps you've taken to make sure it doesn't happen again. If you're not prepared to answer those 4 questions, then the fair answer to a press inquiry is saying, we're aware of the possibility and we're investigating it. I strongly believe that you want to get your message out once and not dribble it out over weeks at a time, because all that's going to do is further enhance the reputational harm to the firm. Now, once you have the malware contained and eradicated, you need to restore your network. That's fairly obvious. But one of the things that you may forget or you may overlook, but I think is critical, is frequently, especially sophisticated hackers will build a backdoor or multiple backdoors into your network so that they're able to get back in at some point 3 months, 6 months, 9 months down the road, especially if you're up against an industrial or a state-sponsored hacker. So I believe a forensic expert may be critical to making sure that there are no backdoors are built into your network and confirming that your system is secure. And I think this is going to be, the message you're going to want to share with your clients at some point in time is you're going to want to make sure that they're aware that your system is secure and that you've had a third party come in and evaluate your system to make sure there are no backdoors and it's secure, and that a client can safely share that information with you again. Now, obviously, during the response process, you need to document what was done, because you may need to address this for a regulator. You may need to address this for a client. If you get sued, you're going to need to know, you're going to need to have this accurately recorded so that you can respond, if necessary, to a lawsuit or some type of administrative claim against the firm. So I think it's critical that you document each step in the process. Again, I believe it's important that your law firm general counsel identify or designate a scrivener, and what that person ought to be doing is identifying when and how the breach occurred, what type of malware was involved, how it was discovered, when it was discovered, what equipment was affected. Everything you step every step you took in the process should be documented. Now again, this is because we have, there's only so much information we can put on a particular slide. Another critical aspect or component of this is you need to evaluate whether any client or firm information was exfiltrated, and if it was, you need to identify what clients or third parties or employees were impacted and what information was taken, because that will address or it will crystallize what type of response or notification you have to bring. Obviously, what you're going to want to do in terms of restoring your network, if information was stolen or if it was encrypted because of backup, because of ransomware, you're going to want to restore that information from backups. Keep in mind that when it comes to ransomware, forms of ransomware can encrypt backups that are connected to your system. So you're going to want to keep your backup information or information used to back up your network not electronically connected to your system. You may want to have it stored separately on tapes in a secure location. Now, we mentioned reporting obligations. There's 4 types. You've got statutory, laws that we're obligated to follow have reporting obligations. Client guidelines are frequently including reporting obligations. Carrier guidelines are frequently including that as well. You're going to have regulatory guidelines, for example, under HIPAA or state data breach notification laws in the U.S. And there's also going to be ethical reporting obligations. And another issue you're going to need to have to consider is whether and when you need to contact law enforcement. If you're basically getting an extortion note from a hacker saying, pay us 20,000 Bitcoin before we provide you with an encryption key, basically that's a crime, and so you're going to have to evaluate whether or not you want to report that to law enforcement. Because many of you may be outside the U.S., it's hard to speak about the reporting obligations. I can tell you that that in the EU, personal data breaches have to be reported quickly to your national authority. And if a personal data breach would adversely affect personal data or privacy of an individual, you may have to also report that to the individual. You need to look at your national authorities' rules and regulations on that. I can tell you that even under the General Data Protection Regulation that's going into place, the Regulation 611/2013 that talks about personal data breaches, my understanding it's going to remain in place. So there are some requirements that require you to quickly respond in notifying your national authority. I can tell you that if the information is encrypted, you may not have to notify the subscriber or the individual's information who was compromised. In that regard, the EU regulation is somewhat similar to what we have here in the U.S. because most state data breach reporting laws have what we refer to as an encryption safe harbor. If the personal information is encrypted, you very well may not have to report under state law. Now,
Steve, I'm going to interrupt because I think the organizers wanted to leave some question time, and I think we're already a bit late for them to do that. So,
well, I've got just a couple quick
up.
things to talk about, and then it'll take me about a minute to wrap up. Obviously, a basic step in risk management is never to make a problem worse. And so when you're talking about when you're talking to your clients, it's going to be critical to outline the steps that you're taking to prevent this from happening again. Training your employees and staff is critical with response, with regard to breach response. You need to educate your firm about the response process, identify team members, who and how to contact, and teach them about possible signs for a breach. Finally, if a breach occurs, you want to evaluate how it occurred, identify gaps that may have been exploited. You want to remediate those gaps. You want to evaluate and improve your administrative, physical, and technical safeguards, and evaluate if additional training for your lawyers and staff are needed. And finally, you want to evaluate and improve your response plan and process. And so with that, I guess we'll throw it open for questions.
Yes, indeed, and Stephen and Anthony, that was fantastic, and it went through virtually every possible aspect that I'm sure attendees will be considering. Although we did receive a couple of questions. The first being, would the speakers have available a tabletop exercise geared to law firms, as it's often hard to find and to design such a process?
My understanding is that the National Institute, NIST, National Institute for Standards and Training, has sample tabletop exercises that are available that you can access electronically.
Right. Okay.
So if you would run a Google search, for example, on NIST tabletop exercises, you should be able to access them. And if not, if they want to contact us, we can obviously get tabletop exercises for them. I mean, it's really just what it really is just, it's hypothetical breach scenarios, and then working with your team through the process. So we've got, I mean, last year, for instance, or 2 years ago, we have a program called LMRM, where we invite general counsel of law firms, and we've run through at a couple of those programs breach scenarios and discussed how they can occur. And of course, we can share that with you. But my first thought would be, think about going to NIST and take a look at what they have, and then if that's not satisfactory, shoot Anthony or me an email, and we'll be glad to share you what we have. But excellent. I think NIST would be a much better resource.
And we received another question by email, and this is from the client perspective on, you know, obviously you want to make sure any potential law firm partners, you know, are up to speed in being able to protect their data and sensitive information. How important is it for law firms to ask about security of a law firm, and how can that be done without harming a potential professional relationship? Is it worth asking for proof or looking at certain documents?
I'll respond to that, Steve. Many large clients have very, very, very detailed, not questions, but requirements. And some of them go beyond specific requirements with questionnaires and audits. And there's a great deal of discussion both within the profession and within groups of general counsel of corporate clients about what is appropriate and how it should be done. But not only is it fair for a client to ask, it's becoming normative.
Keeping one thing in mind, too, from a law firm perspective, because I frequently deal with these, our data practices and policies we treat as highly sensitive information. And if you want to see a particular policy, we'll let you take a look at it in our office pursuant to a non-disclosure agreement. But just as a client wouldn't want to share their data protection practices or how they go about protecting things with third parties, law firms want to be careful too, because we don't want our data security practices to be exposed if someone we share that with happens to be breached. So again, we'll let people look at our policies and procedures in our office pursuant to a non-disclosure agreement. We'll answer questionnaires. We'll explain how we do things in a general way. You know, for example, you may ask, do you use dual-factor authentication? And we would say, yes, we do. And we do this through a combination of hard tokens and soft tokens. And that way, we're not giving away exactly what we're doing and setting us up to be breached if we provided more than that information to a third party.
Interesting. And we have one final question by email, and that's that firms and indeed any businesses, new strategies must pop up of cybersecurity as hackers are, you know, often very sophisticated and take advantage of new technology. Therefore, if a law firm implements strategies mentioned in today's presentation, how often should they be reviewed? And are many new techniques coming up that are really changing the game in this regard?
Well, I think generally speaking, law firms should endeavor to be checking and reviewing their policies and procedures on a yearly basis. Depending upon how detailed and elaborate that is, that could take a lot of work. For example, if a law firm is certified under ISO, under their 27001 standard, that that certification is good for 3 years. So at least ISO certification would require a reevaluation every 3 years. I think
Steve, I want
a lot of clients try to have this. A lot of clients are asking us to do this on a yearly basis.
But I think there's a second element to it, Steve. I mean, somebody either in the firm, in the IT group, or your outside consultant should be watching as the kinds of attacks change and confirming with you or on their own that the defenses that you have in place are good for the new attacks. I mean, most important, for instance, the most basic thing is your malware and antivirus software up to date? Are you downloading the updates? I mean, you know, the threat changes and gets worse every day. So although a full-scale review may be appropriate annually, somebody should be watching the whole time.
Well, to that extent, you're right, Anthony. And if you've got the latest variants of malware like we do, it's updated more than on a daily basis because you're seeing 5 new forms of malware released every second, 24/7, 365. You know, it's the amount of malware that is generated on a global scale is astronomical. So the latest forms of antivirus, anti-malware are updated at least 2 or 3 times a day, and they also have what we call heuristic scanning capabilities, which means that the old generation antivirus protection, they would say, okay, we recognize this signature. The latest variation or the latest generation of antivirus malware will say, well, we recognize this signature is not exactly what's on our list, but it's pretty close. So we're going to flag it and we're going to identify it as a malware, a potential malware that has to be evaluated. So again, what we're talking, if you're talking about antivirus malware, the latest generations of it should be being updated more than once on a daily basis, and you should be looking at heuristic scanning capability. It's kind of like applying fuzzy logic to identifying malware families, to identify something, a signature that may not truly be what's on a list now, but because we recognize there is so much malware being generated on a daily basis that we're going to flag things and contain things that look significantly like something we've seen in the past.
Well, I guess on that fairly daunting bombshell, it brings us to the end of today's webinar. So I'd like to thank you both, Steven and Anthony, for providing such an insightful exploration of these issues. And as mentioned before, their article on this very topic appears in the current issue of World Trademark Review, with details available online at worldtrademarkreview.com. Thank you also to everyone who joined today's presentation, and a recording of which will be sent around to attendees and hosted on YouTube in the next week or so. Until next time, we'll end today's broadcast, and thank you very much, everyone.
Thank you, Tim.
Thanks a lot.